Happy Mardi Gras. Today I have for you a big fat rant. Our government is broken, it is corrupt, it is reparable, I think, but everything that you think you know that's wrong with it is true and is probably worse than you think it is. I want to go through the process that I've been going through for the past several months trying to get a law passed. This started back in, I'll say November, when I was invited to present to the Senate Judiciary Committee. Now, I was given a pretty narrow scope. I was asked to give examples of specific breaches of contract with a specific surveillance provider that had become locally well known and poorly regarded. So this was Flock. We were fighting Flock at the time, trying to get their contracts canceled locally. We did eventually succeed. But in the meantime, I got to go to the Senate Judiciary Committee and give this really cool presentation. Like, that was a personal invite that I received, and that was awesome. A lobbyist was also able to give presentation that same day and elected to broaden the topic and go with the, well, Flock is just one vendor. There are other ALPR vendors. This is such an important tool. So from day one, we were fighting on uneven ground. Now, the presentation was pretty well received, and I got invited to a work group. So this work group had 3 legislators. The ACLU had a national policy representative. There were 2 high-ranking law enforcement personnel, one from a municipality and one from the state. There was me. And there was a lobbyist. Not someone who works in law enforcement, not a stakeholder, not somebody local, just a straight-up lobbyist. The way he presented himself, I thought he was part of law enforcement, so it didn't even occur to me until a little ways into it that this guy's not a law enforcement officer. He's just been a lifelong lobbyist because that's what his daddy did, and that's what he gets to do now. So we meet. We meet a couple times a week. We meet for weeks on end. These meetings go for hours. My cats are fighting. And we are just going around and around and around in this meeting. And we finally come up with this draft legislation where nobody is happy about it because that's how compromise works. But we've all got stuff we can live with. We argued about data retention periods. Law enforcement wanted it longer. The rest of us wanted it shorter. We fought about public records request exemptions because public records is how we got a lot of the research that we needed to prove that these companies were doing heinous things with this data. We were writing legislation for a technology that is relatively new in the world of tech that is being legislated on. Legislation moves really slow. Tech moves really fast. License plate readers have been around for a while, but the Flock type of automated license plate reader that is AI powered and highly networked is relatively new. So writing tech legislation means you have to have a huge list of definitions at the top of the bill so that people know what you're talking about. And this happens with a lot of legislation. It's not just tech, but especially with tech. you need to know what you're talking about, because you cannot expect the average person reading it to automatically know what you mean when you say hot list, or what exactly counts as license plate reader data. So there were a lot of details that we had to work out. The thing that I fought hardest for since the very beginning was encryption. I wanted this data to be end-to-end encrypted, because that means that law enforcement still got to access the data. They still got to have this tool that they claim is so important. But end-to-end encryption means the vendor, the corporation, does not get to access the data. They can't sell it or trade it or hand it over, because they can't access it. So what happens is the camera would take the picture or the video, the data would get processed on the camera and then encrypted. So it would get like jumbled up, and then it would go through the network, where it would get stored on a server somewhere until it was grabbed by law enforcement doing a search. And then only there, on the law enforcement device, it would get decrypted and turn into something useful again, a photo or information. This is really important, because Flock got caught so many times last year handing data over to ICE and to other federal agencies just because they could. And they did this a lot of times without law enforcement's consent, even though they kept saying that law enforcement owned the data. Now, we could write into the law something that says the vendors are not allowed to share the data with anyone except their customer. And that's a pretty reasonable thing. The problem with that is, if you have something like a judicial warrant, that means the feds serve a legitimate warrant, a subpoena to the vendor. You cannot compel the vendor to just ignore that. That puts them in a world of trouble. It's absurd to ask them to ignore that. But if they don't have access to the data in the first place, there's nothing for them to hand over. And we've seen this in action with Signal messaging before. Signal has received a number of warrants. It's not that they are just refusing to comply because they're so ethical. They've built a system where they cannot access the data, and when there's a warrant, there's nothing for them to hand over. And that's the standard that we want for a company that has cameras all over the place, logging where people are all the time, what their habits are. I can't go to the gynecologist without passing 2 of these cameras. That data is precious and should not be in the hands of some for-profit company. And so we finally got to a point where we were kind of all in agreement, more or less, with this legislation. The draft gets published, and the Senate Judiciary Committee has a hearing. At this hearing, the public is allowed to give comment. You sign up and you can say that you oppose, or that you are in favor, or you can say that you're neutral and just still give a public comment, which is pretty cool. So we have this amendment. It's the -2 amendment, because it's the second time they amended it. And this legislation is supposed to be part of this massive safety omnibus bill. Now, since then, all these pieces have been gutted off of it, so it's no longer this big safety bill. It's just the ALPR stuff now. So we go. They weren't even sure when the hearing was going to be. They weren't sure when they were going to publish it. I went there on Monday. We waited. It never came up. Finally, it was like, okay, Wednesday we'll have the hearing. They publish this draft an hour before the hearing, so you have 1 hour to read through all of these pages of legal writing to see if you actually got the thing that you were vying for. And we do. We have it. It's there. There's a lot that's wrong with it. There's a lot in this bill that is not great. But we had the encryption language, and that was what mattered the most to us. I testified. I signed up as neutral because you have to sign up by a certain time, and the language hadn't been published yet. So I signed up as neutral and figured I'll go where I need to go with it once I find the draft. There was a lot of public comment. It's good. There's engagement. Law enforcement gave a lot of comment in favor of the bill. I'm sure they had reservations too. So that was dash 2. In subsequent days, this thing is amended over and over and over and over again until finally it's time for the Senate Judiciary Committee to have their work session on it and actually vote. And the lobbying is going on all the way up until the end of it. And I know this because I was in the Capitol constantly, and I would see these people, these lobbyists, grabbing the senators and talking to them. Now, it's all open information. You can see which lobbyists have been contracted by which organizations. You can see that Flock has these list of lobbyists. Except it's not actually all that clear. Because while Flock was at least transparent enough to contract with a firm and be there in the system as having hired lobbyists, Axon did not. Now, Axon is who the state uses as their ALPR vendor, and they've got contracts that go for years and years and years. The current contract goes through 2030, which feels like forever away. The whole time we're in this work group, Axon is affecting this conversation because the person from OSP who's in this work group, and now I feel a little bit weird about the, separation of the branches of government, having actual law enforcement people directing legislation, but that's a different conversation. But we have this vendor, Axon, this corporation, who is lobbying through a law enforcement officer to get this legislation written a certain way. I think that's wrong. And it was so frustrating. And we've got the emails. I mean, this is more or less on the up and up. We've got the emails that show Axon lying to law enforcement, and then law enforcement bringing those same lies into this work group to change how this legislation is written. The day of the Senate Judiciary Committee work session, the Chief Information Security Officer of Public Safety for the state of Oregon writes a letter to the chair of the Senate Judiciary Committee. Now, we had a meeting with him the day before, because he wanted some input, and he wanted this legislation to basically say that he got to make the rules about encryption, which is just weird, and it's something weird to ask for this late in the game. But as we're sitting there talking to this guy, we realize that he has no idea how ALPRs work. He had no idea that this bill was meant to regulate ALPR use throughout the state. He thought it was just for OSP, which again is odd. He was arguing about different types of encryption in a way that told me he did not understand what we were asking for. It was a really frustrating conversation. On top of the fact that I had tried to get subject matter experts into this work group early on because it was really apparent that there were people in the room that did not understand what we were arguing for. And you can try and break down technical things into layman's terms, but you do kind of lose some authority sometimes when you do that. And I wanted a third party independent subject matter expert in there because I felt like they didn't believe what I was saying about how end-to-end encryption works. What they did to placate that was bring in 3 sales engineers from Microsoft to talk about how great their Microsoft Cloud Azure system is. And I felt like I was living inside of an infomercial. They did end up verifying for me, at least, that end-to-end encryption is different from encryption in transit and encryption at rest. Ergo, the state's current vendor is not in compliance with the legislation that we're trying to write. So I did get that out of it. Sorry for telling this out of order. So back to the day of the work group meeting. The work session. So the Chief Information Security Officer for Public Safety for the state of Oregon writes a letter to the chair of the Senate Judiciary Committee saying that he has no position on this bill, but that we should not be defining end-to-end encryption because technology might change. And that argument is so wrong on so many levels because we worked so hard to have a definition that said that only the law enforcement owner of the data could decrypt and access and grant access to the data. So we didn't define any specific algorithm to use. We didn't insist on any particular architecture. We just defined how this should be working so that the vendor can't access the data. And that does make it future-proof. If a new technology comes up, that's fine, you can use it as long as the thing that technology does is make sure the vendor technologically cannot access this data. And the really messed up part of this, there's so many messed up parts of this letter. So first of all, that part is wrong. And then the CISO goes into talking about the state's vendor and how this is bad for their business model. I mean, he just comes out and says it, that this will affect their business model. To hell with security for people or privacy for people. This supposed neutral third party is telling the chair that this legislation is bad for the business model of one single vendor. There was some other dumb stuff in it, but at the bottom of this letter that is, a PDF attached to an email, he writes, CC Rebecca David. And that's the commander for OSP who was in the work group, who kept bringing all of our issues back to the vendor so that Axon could have a say in this work group despite not having registered as paying any lobbyists. Because they're not paying any lobbyists. They are lobbying through law enforcement. I don't understand why you write CC at the bottom of a letter that you are emailing. Like, that's not how email works. And all that did was show us who went to him and why, and expose exactly why this letter got written. That whole thing feels so gross and wrong and like it should be illegal, but I can't figure out how. Up until the very moment that this work session was called to order, lobbyists were up on the dais talking to senators. Now, I got called out into the hallway before the session started because there were senators that had questions, and that's fine. As long as you're standing there and there aren't so many of them that they are a quorum, there's not enough of them there to make it like they could make some kind of decision. So they had some really legitimate questions. Are there any vendors already in compliance? What does this mean for new contracts as opposed to contracts that already exist? I mean, I had 10 seconds to try and explain to somebody what end-to-end encryption was. That's not great. That's not how this should work. But the Oregon legislature is in a short session where they have 35 days to pass all the legislation that they are working on, which means that everyone is rushing through everything and nobody is reading through all of the bills that they are voting on. I don't think that's a proper way to govern. People are voting on things that they don't know anything about. You have 10 seconds to explain to someone what a bill is, and they have to take your word for it. And that is not any kind of way to run a government. And every other year, this is how our state government runs. That's probably another story. So these lobbyists are going all the way up until the minute that this session is called into order. Now, there was a recess, and somehow the amendment that got drafted in the morning that we thought they were going to vote on was the -11. So remind you, we started at the -2. This is 9 more amendments later. The morning of the work session, we get the -11. And then after the work session starts, we get a -12, a -13, and a -14, just published out of nowhere. And I'm going to pause this. So that morning we get the -11 published. And then while the work session is starting, they publish 3 more amendments. The -12 combined a couple of the earlier ones, fine, whatever. The -13 and then the -14 took out the definition of end-to-end encryption. They did not change the requirement for it. They just took out the definition. Now, we're back to what we talked about earlier, where you've got technical legislation and you need to have things defined because there's not otherwise a legal definition of end-to-end encryption. If you work in InfoSec, if you work in cybersecurity, if you are a tech and privacy enthusiast, you know what end-to-end encryption means. But if you are a legislator with a background as a prosecutor, as many of them are, I don't expect that you have ever even heard that phrase. If you are a law enforcement professional, I don't expect that you know what that means either, so I'm not sure how you're supposed to know if your vendor that you're looking at is in compliance. I got called up to testify once the work session started to again try to answer some questions that really should have been asked way earlier, but that realistically couldn't be because nobody has the time during a short session to worry about somebody else's pet bill. Everybody's worrying about their own thing that they think is most important. So we get this senator that I had had a meeting with prior, who really was very dismissive and kind of poo-pooed a lot of stuff. I I did a little bit leverage my 911 dispatcher background, and that seemed to help, which again is really messed up. And I tried to explain to him that we're not anti-law enforcement. We're trying to just protect this info from the vendor. Because if you don't take that stance, they won't hear you out at all. And I had found a vendor that was using end-to-end encryption, because part of the argument that law enforcement was making on behalf of their preferred vendor, Axon, was that this was simply impossible to implement. But I found someone that was doing it. It does exist. And it didn't matter. This guy had his mind made up because he was lobbied by people that have money that they donate to his campaign. At the end of the day, that's all this is. There's so much law enforcement lobby money being thrown around the Capitol. And, I put a ton of time and effort into this work group and into these hearings, and I'm not being paid for it. And it costs me money to drive from Springfield to Salem and back. And it costs me money to miss work to do these middle of the day work group sessions. And I'm not getting anything out of this. I'm not getting lobby money out of this. There's no group of concerned citizens that is giving me money to lobby for them. I'm doing this because I understand what is happening here and because I care about people. But meanwhile, you've got thousands of dollars being just tossed around by people who don't give a damn about anything except money, and it works. The legislators are so deferential to law enforcement, and law enforcement gives them so much money through these groups like the Oregon Association of Chiefs of Police. I guess I don't know. It just I maybe I should have seen this coming, but leaving everything as is and just deleting a definition was not something I anticipated at all. And it's so ridiculous that was offered as a possibility. And the two senators who were trying to vote earlier to make exceptions for law enforcement to work with ICE voted against the amendment that had the definition and voted for the amendment that omitted the definition. This bill is completely worthless now. There's no way to enforce any part of it, and it doesn't make sense. It doesn't make sense, and it was slimy, and it was unethical, and it was wrong. And what happens now is the bill passed the Senate Judiciary Committee. It will go to the Senate floor, where the entire Senate will vote on it. And they will probably pass it because it's got bipartisan support. Once it passes the Senate, it will go to the House Judiciary Committee. And they can choose to pass it, they could choose to amend it, or they could choose not to pass it. If they pass it, it will go to the House. The House will vote. And then we've got both chambers have voted yes. It will go to the governor, who can either sign off on it or veto it, or in a fun Oregon special third option, she can do nothing with it, and then it will pass, but it'll pass without her signature. I don't know why that's an option, but it could happen. So that's where we're at. This is, how a bill becomes a law, but even before that, this is how a bill comes into existence. And it starts with a work group. As promised, this was a big fat rant. Happy Mardi Gras.